When I looked at the topics for discussion today, it was clear that we could have a whole day seminar on each of them as they're so key in women's health. Consent in birth, women's mental health, birth injuries, breast cancer, GBS, abortion rights, all of these issues are incredibly important, could be discussed in much more detail. But the purpose of today's event is to raise awareness. I'm going to talk about consent in birth given the developments in the case law and touch upon women's mental health and some recent cases my firm have been involved in. Finally, I want to talk about birth rights and consent. I know we have many experts here today, as well as very senior lawyers, so I know that they are well aware of the case law. But for those of you who don't, I want to take you through the fundamentals of how consent in the recent case law to illustrate what consent should involve. The decision in Montgomery is an iconic case. It changed the landscape for consent for patients. And I think it is because we had not had a vehicle for change before, and the decision in Montgomery has provided us with a real opportunity about women's rights in birth. There is so much to say on this subject, so I'll try and cover the really salient issues. But I thought I would start my talk today with a quick summary of Bolam, the old legal test for consent, go through the decision in Montgomery and the latest interpretations of Montgomery in a case called Webster, the most recent case of Hassel, and one of my own cases. Finally, how these judgments have changed the landscape of consent, which was much needed in my view, and has had an impact on women's rights in birth. So let's start with Bolam. This case was decided in 1957, so the law has not changed since then. And it sets out a rule for assessing the appropriate standard of care in medical negligence cases. A medical professional must show that he acted in a way that a responsible body of doctors in the same field of, or a similar experience would regard as acceptable. And this test has endured for many years in terms of medical treatment, but also for consent. What would the responsible body of doctors have done when consenting that particular patient in those particular circumstances? Bolam, in my view, is archaic and paternalistic and allows the doctor to make decisions, decide what she thinks is right for the patient to know, rather taking into account what they might want to know. The patient has a right to determine what shall or shall not happen to their body, and they have the right to decline treatment. The law needed to move on, and Montgomery allows us to do that. Montgomery was the perfect case to allow the opportunity for the Bolam decision to be challenged. It presents the perfect storm in which we had the opportunity to attack Bolam. In order to try and understand the judgment, I think I should give you a summary of the facts. Mrs. Montgomery was pregnant with her first baby in 1999, and she was a small lady stature. Intelligent, she was a graduate of molecular biology and worked for a pharmaceutical company. Her pregnancy was agreed to be high risk. She was a long-standing insulin-dependent diabetic, and we know that diabetic mothers grow excessively big babies. They also grow lots of deposits around the top of the shoulders, fat deposits, and there's a particular risk that they have some problems delivering vaginally. There's also the risk of shoulder dystocia, which is obviously a dire obstetric emergency. Shoulder dystocia will happen in about 10% of diabetic mothers, and if this happens, the mother should be put in the Roberts position and suprapubic pressure should be applied to stop the shoulder being stuck under the pubis. There is also a great danger that the cord can be included between the shoulder and the mother's pelvis, causing the baby asphyxia. Mrs. Montgomery was anxious because she was small and she knew she had a big baby, very high-risk pregnancy, and measured the size of her baby fortnightly and plotted a graph as the baby was getting bigger and bigger. And Mrs. Montgomery was worried and frightened and asked her obstetrician more than once, would she be okay as a tiny woman to push this baby out? She specifically directed her questions about the risks. Her obstetrician chose not to tell her about the 10% risk and told Mrs. Montgomery that she would induce her labour if there were any problems. She also said she reassured Mrs. Montgomery that if things did go badly, that she could have a caesarean section. She told her nothing about the extremely concerning real risks of her pregnancy and shoulder dystocia, and did not offer her a caesarean section. When asked about this in evidence, she said if she had told Mrs. Montgomery about the risk, when you offer these women caesarean sections, they take it. It is not in their maternal interests. Sadly, a problem did arise in Mrs. Montgomery's case. Her labour was induced and the labour became obstructed because the baby was so big and she was so small. And Dr. McKellen, however, astonishingly did not order a caesarean, despite saying that she would do. Instead, she gave syntocinon, which augments the contraction and causing her baby to be forced down further. The baby's head came out, but the shoulders became stuck and the baby started to asphyxiate. The emergency ensued, the Roberts position failed, and by this time the caesarean section was not possible as the baby's head was too low. They then had to do a Zampanelli manoeuvre, I'm not sure if I pronounced that correctly, but tried to push the baby's head out, and they happened to open Mrs. Montgomery's suprapubic opening. The midwife tried to cut through this, but she did not have the appropriate equipment, and she had to use the midwife ended up having to use forceps to pull the baby out, and of course by this time that poor baby had a brachial plexus injury and was catastrophically brain damaged. Astonishing, the case was defended, and it was considered appropriate not to inform Mrs. Montgomery of the risks. So the case ended up going all the way to the Supreme Court, and Mrs. Montgomery won. And this did not happen until 2015. The claimant's lawyers argued that the principle of Bolam test was wrong, that the judges expressed their view clearly, stating that the test now for information disclosure should mirror what the guidance was in the GMC. The test should be a patient-centred test. The doctor must take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and any reasonable alternative or variant. The doctor is therefore under a duty to take reasonable care to ensure the patient is aware of the risks and that the test of materiality is in the circumstances of that particular case a reasonable person in the patient's position, what they are likely to attach to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach to that risk. The doctor has to take an intelligent and rational look as to what the reasonable person would want and need to know, and then to look at about that person himself. Patients have individual special characteristics which may influence what that patient would be considered to be material. In the absence of consent, it is unlawful to do anything to a patient. And so after Montgomery, the case law came through, and the next case was Webster, which was significant. The law had been reiterated in this case, and Sebastian Webster suffered a catastrophic brain damage as a result of hypoxic ischemia, which occurred between 48 to 72 hours before delivery. In October 2012, at 32 weeks, Sebastian's mother was admitted with bleeding and a headache, and a doctor wanted to admit her and warned her of the risks of placental abruption. She was reassured and went home. In November, scans were conducted, and the consultant failed to note abnormalities. The baby was small, there was excess liquor and an asymmetry in the head circumference, and he was negligent in failing to organise further scans, and that was admitted. However, on the 26th of December, Sebastian's mum felt unwell and she was due on the 27th. She was seen in the morning. The same consultant decided she was well enough to come home and that she should come back at 41 weeks for her induction. That was 1 week later. The claimant's case was that his mother should have been given an opportunity, one, the choice about being induced there and then, and being fully aware of the anomalies, or whether two, to come back at 41 weeks. The defendant argued that even if the scans had been done, that they would have been reassuring, not giving rise to the need for heightened vigilance or advice about dangers, and the claim as a result failed at first instance, and the judge applied the Bolam test. The case went to the Court of Appeal, and the judge applied the Montgomery criteria. I think had the mother been advised that she should proceed to induction or that there were increased risks in waiting until the 6th or 7th of January, she would have wanted to be delivered. And I think she was fed up of the pregnancy and the lack of well-being, and it was the due date that she had in mind. She would not have wanted to put it off, since the prospect of induction was looming in any event. The mother had a degree in nursing, and her evidence was any suggestion of a risk, I would have wanted him to be delivered. So by the 27th of December 2012, she would have been told that her pregnancy was subject to unusual features, if not complications, and she would have needed to know the implications of that for her baby so she could make a decision about the birth, and being given the information that she would have been given is clear that she would have chosen to proceed to induction on the 27th of December. The mother made an excellent witness, and the claimant succeeded at the Court of Appeal. And this case is interesting because it overturns the first decision of Bolam and applied the responsible test that takes account of Montgomery. So the law was developing We now turn to a really recent case, which was February this year, my colleague Olive Lewin's case on consent. And it's not an obstetric case, but it's very interesting in terms of the extent to which consent is considered. There we go. It's a hassle, and this revolved around... Have I gone back? That one? No. There we go, sorry. The case revolved around the treatment of Mrs. Hassel, which she received as a defendant's hospital in June 2011. Mrs. Hassel was suffering with ongoing neck and upper pain and underwent for a C5, C6 decompression and disc replacement surgery on the 3rd of October 2011. Her spinal surgeon was Sean Ridgway. During the course of the procedure, Mrs. Hassel very unfortunately suffered a spinal cord injury, which rendered her paralysed. The value of the claim was sorted out before they went to trial, but breach of duty and causation was never, ever agreed, and so they went to trial. Mrs. Hassel argued that she was not warned of the risk of paralysis, nor was she offered conservative treatment, such as physiotherapy, prior to undergoing the procedure. And it was her case that she'd warned of the risk, she would have considered it too high and not gone ahead. She also argued that Mr. Ridgway failed to carry out the procedure with reasonable care and skill. The trust stated that Mrs. Hassel was properly warned of the risk, the surgery was reasonable and proper. The decision is an interesting one because it largely turned on what Mr. Ridgway said, or rather didn't say in his witness statement and during the course of his evidence at trial. In addition, in his correspondence, he had written prior to the surgery, had not properly set out the risks of paralysis. Mr. Justice Dingmans found that Mr. Ridgway had erroneously concluded that Mrs. Hassel had already undergone physiotherapy for her neck pain, and because of his mistake, did not properly discuss conservative treatment with her. Had he discussed conservative treatment and the options, Mrs. Hassel would have gone away and made that correct assumption. But there was no criticism of the care that was given. The quote we have from Justice Dingman is that I find that Mr. Ridgway used reasonable care and skill in carrying out the operation, and that I am unable to identify the cause of Mrs. Hassel's spinal cord injury. I find that Mrs. Hassel did not give informed consent to the operation, and that if she had been given the information about material risks and conservative treatment, Mrs. Hassel would not have agreed to the operation on the October the 3rd. The judge also said, whatever Mr. Ridgway's strengths as a surgeon, when carrying out the operation, Mr. Ridgway was not a good communicator about risks of the operation. I mean, it's very interesting because obviously the care was completely appropriate, but the consent process was not adequate. So I'm going to just turn to, and hopefully I'll go the right way with this, case X. A case that I've recently received damages for my client, and it's an interesting obstetric case. And it's a good example of how they are now coming to play, and I think perhaps all the sort of obstetric midwives in the audience will be interested. So my client gave birth to her son in August 2013, and prior to going into labour, she'd repeatedly told staff that she wanted a natural vaginal birth, was not willing to consent to a forceps-assisted delivery. She was extremely anxious about the associated risks. She had a very strict birth plan, and she'd experienced a delayed second stage of labour, which, when it became clear that a natural vaginal birth would not be possible due to a narrow pelvic outlet and the size of the position of her baby. She was pushing for over 2 hours, but there's no visible progress, and the likelihood of the need for an assisted delivery was explained to her, who stressed as before that she did not agree to this and would elect for a caesarean section if natural vaginal birth was impossible. However, she ended up agreeing as to the safest course of action following administration of pain relief. She was transferred to theatre and a spinal anaesthetic was administered, and following this, the fetal heart rate began to decelerate and she became bradycardic. The consultant obstetrician advised that an assisted vaginal delivery would be the best way to proceed, and so she signed a consent form for a trial of forceps to proceed to section if necessary. However, my client said that she felt forced to do so under considerable pressure and feels that she was not given the time to read the form properly. The consent form documents that were there was a delay in consent, and she didn't have time to think about the decision. The consultant obstetrician proceeded to undertake the delivery with the assistance of the forceps, and 3 pulls were attempted, during which she was slipped down the bed. Both her and her husband became incredibly distressed. The case that midwife has stated that she signalled to the labour ward and the coordinator that she felt the attempt should be stopped, but a 4th pull was then attempted and there was no advancement and attempt was abandoned. The maternal right forceps was removed and manual rotation of the head with the left forceps in situ was attempted. And this was unsuccessful. The left forceps was removed after around 6 minutes, and the decision then was made to proceed to a category 1 section. The baby was delivered by caesarean section shortly afterwards, and he was pale, had a deep laceration on his right eyebrow, he was bleeding, he had swollen right eyes, transferred to the NNU with respiratory distress, and required continuous positive airway pressure. He sustained facial scarring, and also his mother suffered paraclitoral laceration, which was sutured and has been extremely upsetting and traumatised by the birth. During the case, there were interesting comments made by the midwife, and when we got the SUI report, we had disclosed to us a statement by the midwife. It was very compelling evidence from her. She stated that, I noticed that Mrs. X had had a very strict birth plan and highlighted very clearly that she wanted to avoid an instrumental delivery at all costs, and that a caesarean section was preferred in an emergency situation. I discussed her plan with her, confirmed her wishes and if there were any changes to her preferences. After this conversation, I'd learned that she'd done extensive research and background reading into guidelines as NICE and the Royal College of Gynecologists and was knowledgeable in the recent statistics. On impression from my VE findings, I felt that she would have been very difficult to deliver to achieve vaginal delivery, and on palpation it felt that it was a good-sized baby for her. I left her in the room and informed the coordinator and the lady standing with her at the time that I had assessed her, and from my vaginal examination findings, I said that it was very likely that she would be able to deliver it. It was a big baby with caput +++. I also said that the doctors would really likely need to assist after the hour and will need their assistance for delivery sooner rather than later. I told the registrar the same findings that I told the coordinator, and that the patient had a phobia of an instrumental delivery, and that would be opting for a caesarean section if she needed assistance. I stressed that it would be very difficult delivery, and that I wanted them to review after we gave her an hour of pushing. She was given syntocinon, and at 11:29 hours the forceps was applied, and at 11:30 the consultant did the first pull. Contraction was quite short. The coordinator and the SR present, and with me palpating whilst I was holding the abdominal transducer in place to auscultate the fetal heart rate. Syntocinon was increased, and there was a second pull of forceps done by the consultant. The vertex was visible but still appeared high, and delivery was not imminent. At 11:35, midpoint of the third pull, the consultant asked the registrar to take traction of the forceps. And at 11:37, with the fourth pull, the consultant took over the traction. It appeared high, and I signalled to the coordinator that we need to stop. And I quietly informed the consultant that she had pulled 4 times, to which replied to the coordinator that it had only been 2 good pulls. At 11:37, the forceps delivery was abandoned, and according to the statement of the labour coordinator, it took approximately 6 to 10 minutes to disimpact the fetal head and remove the forceps. 1 forceps was stuck in position. The consultant appeared to be pushing the head up to see if she could release the forceps, and release the forceps after about 6 minutes. And of course, then inevitably, my client had to go for a caesarean section, of which she wanted initially in the first place. So where do these cases leave us with consent? In my view, a much better position. Mothers are usually well, healthy women who are going through a natural physical process and they are usually not ill. They have the right to autonomy with their body as they carry their child. They should be fully informed about their pregnancies and mode for delivery and the potential risks for them and their baby. It cannot be right that a doctor can decide what he finds he or she should tell them about the risks of your pregnancy or the risks of the delivery. Women must be informed and have autonomy of choice, and this, of course, is set out in the Human Rights Act. It is a fundamental right to determine what should be done with your own body. And as Lady Hell said in Montgomery, as NICE puts it, pregnant women should be offered evidence-based information and support to enable them to make informed decisions about the care and treatment they have. Gone are the days when it was thought that on becoming pregnant, a woman lost not only her capacity, but also her right to act as a genuinely autonomous human being. I've also outlined some of the GMC guidelines, because in my view they actually tie in with Montgomery, and the case law was way behind the actual GMC. The GMC guidelines entitled Consent Patients and Doctors Making Decisions. So a doctor may recommend a particular option they believe is best for the patient, but they must not put pressure on patients. Adverse outcomes from proposed treatment should be identified, including side effects and complications and failure of intervention to achieve aim. The patient must be told of any serious adverse outcomes that might result from treatment if the likelihood was small. The patient's decision to refuse treatment must be respected, even if it is wrong or irrational. A doctor must not put pressure on a patient to accept their advice. Her emotional and psychological well-being is key. And care of women in labour, that women's emotional and psychological needs are considered at every stage. Each woman and her partner are provided with a level of evidence-based information necessary to consent to all procedures. Therefore, the broad nature and purpose of each procedure is explained prior to obtaining consent. Every woman and her partner should expect to be treated with respect and encouraged to be actively involved in decision-making. Healthcare professionals should assess the needs and expectations of the woman and her partner, making use of the birth plan. And the initial assessment of a woman in labour should include history-taking, active listening to a woman's story, and always considering the evidence. If we look at the guidelines of local trust and the GMC, we can see that the Boland was completely out of date, and Montgomery has only just updated the law to current day practice. I know there are concerns from medical professionals about Montgomery, but I would say I think it is your friend. It provides certainty, which obliges you to consent properly. It improves the consent process for patients, so they're more informed, and it protects doctor from the lack of clarity in Boland. I believe it is part of a doctor's professional skill to be able to communicate with their patient. He or she should be able to judge their patient and explain to them in a manner they understand what are the risks, but also listen to what they want from their birth experience. We cannot patronise patients with the argument that it is best they do not worry their heads about the risks. Of course, if the patients do not want to know the ins and outs, then of course it's appropriate to do that, and it's set out in the judgment. But I do believe that women must be fully formed. To be aware is to be informed, and if they have a healthy and safe pregnancy and delivery, which is very likely, then knowing the risks is not problematic. But things can go wrong. Babies can die. Women do get terrible birth injuries. Babies suffer brain damage, but if they do, they have a clearer understanding of the risk and help the mother then understand what has happened to them. From my experience, being consented properly would improve the situation, as there would be more forewarning. When I speak to women who've suffered trauma, they remember it like it was yesterday, and it terribly impacts on potential future birth. This requires discussion prior to delivery, and exactly the same way that women will be better prepared to recognise their symptoms for what they are and to seek early help should they suffer the misfortune, for example, of such an injury like an anal sphincter injury. If they're aware that it can and does happen, they will be prepared to engage in the decision-making progress during their deliveries if they are armed with the information before that. It still shocks me that so many women are not aware of perineal tears. I know we've got to talk about that later, but after giving birth and the terrible impact on women's lives, it becomes embarrassing for them. So it is not mentioned, and these women have to live with that for the rest of their lives. A lot of our clients have said that I didn't know such terrible things could have happened as a consequence of giving birth, and if I'd known, I'd have gone back to the doctors and asked how this could have happened, what I need to do. So I think this really nicely leads me on very quickly to some mental health issues, particularly the impact of post-PTSD and postnatal post-traumatic stress syndrome, psychosis, and other mental health issues, which will be discussed in more detail. And I think Zoe's going to talk about mental health issues after me. Obviously, I'm not a clinician, but as lawyers, we do deal with clients who've suffered some trauma after birth all the time. And often we are the first people they actually talk to. It's a tremendous responsibility. There is reported in the region of 200,000 women who suffer birth trauma, according to the Birth Trauma Association, 10% of whom are left with PTSD. This, of course, has a knock-on effect. Counselling, unable to work, potential damage to the children and babies, which affect, obviously, their education in the early years, as mentioned by Tracy. And in the Department of Health, Safety, Safer Maternity Care 2017, the Embrace UK report on maternal deaths from psychiatric causes, suicide, have more than doubled from 6 deaths in 2009 to 2011 to 14 in 2012 to 2014. Postpartum psychosis is diagnosed by hallucinations and paranoia and delusions, but is still rarely diagnosed. In fact, we recently represented the family at an inquest where the mother died after suffering from postpartum psychosis. The condition is rare and it affects about 1 in 1,000, but she was admitted into a mental health trust and died in tragic circumstances after the admission. The observation and monitoring of our client's daughter was not done in accordance with the trust policies. So there must be more awareness of this condition so that it can be recognised and treated appropriately. Very recently, it's been mooted by a cross-party group of 60 MPs that have written to Steve Bryan, the Minister for Public Health and Primary Care, that there should be a 6 weeks mental health checkup after birth to tackle postnatal depression, anxiety, postpartum psychosis, and other problems related to having a baby. They believe that checkups would reduce the damage experienced by women, children, and families suffering psychological harm, which can go undetected for long periods. This then erodes their ability to bond with their children and, of course, impacts on those crucial years of their development and education. I believe that such a scheme should be put in place. Its support is key and could help prevent tragedy. The scheme would cost £20 million, whereas mental health problems cost in the region of about £8 billion a year, and I can well believe that. All the clients I've dealt with inevitably had a traumatic birth, and often the fathers too, that it has a massive impact on their mental health. I am a lawyer and I do see the NHS and I act on behalf of patients that have been injured. But this event today is not for us lawyers to gloat about our successful cases. It is to increase awareness about the issues that women's rights in birth should be respected and consent should be done appropriately. That in turn will impact on their outcome of their health, will impact on their families and the support of their children. It will also potentially reduce the cost to the NHS. So I think it's something that we should really think about carefully. And finally, I just wanted to say thanks to our fabulous charities, and I would be grateful if you could all please just support Birthrights, GBS Support and MASIC today. Thank you very much.